Hello. This is your introduction to Incoterms. In this video, I will be giving you an overview of what Incoterms are. There are going to be two following videos, one focusing specifically on all modes of transportation and another one focusing on Incoterms just for marine and waterway. So this is just your intro to Incoterms. So Incoterms are sometimes called terms of trade. What that means is they are international commercial terms. So that's where you get Incoterms from. So sometimes you'll hear terms of trade, sometimes you'll hear Incoterms. So terms of trade, Incoterms, are used between a buyer and a seller to clarify and define their responsibilities in a contract of sale. When these terms are clear, you know about your ownership, your risk, your documentation requirements, all of those things are also clear. The most important thing about Incoterms is it addresses two important issues. That is the specific point of the transaction where the risk of ownership passes from the seller to the buyer, and the specific point in time when the responsibilities for payment of freights and other charges pass from seller to buyer. I'm not talking about the contract. I'm not talking about what the freight is worth. What I'm talking about is the freight charges. Who's going to pay for trucking? Who's going to pay if there's any demurrage or detention? Your Incoterms are what tell you that, whereas your contract of sale does not. So as I said in the previous slide, Incoterms are between the seller and the buyer. So what is the role of the freight forwarder in this? Well, the role of the freight forwarder is to act as an intermediary. They're supposed to be knowledgeable and clarify the trade terms for the buyer or the seller so that you can avoid any disputes in the future. So Incoterms are basically between the buyer and the seller. Under a sales contract, Incoterms clearly explain the division of costs and risks between the buyer and the seller. My favorite example to give is you buy a car on Kijiji. You transfer the money to the seller, and the seller says he's going to drive over the car. On the way to your house, the seller gets into an accident. Who's responsible is it for paying the cost of fixing the car now? Is it the buyer or the seller? If you had used Incoterms, this would be defined for you and you wouldn't be finding yourself in a dispute. Another party that plays a big part in Incoterms are banks. You're dealing with money, so that's where the banks are going to come in. So a company's choice of Incoterms can determine who's going to pay any costs related to distribution, shipping, customs, etc. So that's where the banks get involved. Next up, you have your freight forwarders and service providers. They are involved in Incoterms because they have to be aware of the contractual obligations of their customer, whether it be the buyer or the seller. This is also necessary for settling payment disputes between the buyer and the seller. Again, not direct involvement, but a knowledgeable intermediary. And the last party that has a role are insurance companies. Contracts that have CIF or CIP, they contain insurance. So the insurance company, again, has to be involved if you're going to put an Incoterm with insurance in it. This is an important slide. This is the scope of the Incoterms. Incoterms apply only to the trade of tangible goods. So that means solid goods that you can touch with your hands. I'm not talking about software. I'm not talking about intellectual property. They only apply to tangible goods. Also, they are not, I repeat, they are not international law. They are a set of rules, but they are not a law. Next is they do not apply automatically to contracts of sale. They do not address price, and they do not address ownership. So again, the scope of Incoterms apply only to tangible goods. They are not international law. They do not apply automatically to contracts of sale. They do not address price, and they do not address ownership. Some people get confused when they hear the transfer of risk and the transfer of property rights. Just because you change possession of something, so ownership does not actually change. Think about if you give a a package to a delivery company. That delivery company does not now own that package. They're just moving it on your behalf. So you need to think of it along those lines. So you don't want to confuse transfer of risk and the transfer of property rights. So once again, I'm going to reiterate, Incoterm rules do not deal with the transfer of property rights in the goods. They are only rules for interpretation in the terms of delivery, not in the terms of the contract of sale. We're keeping them two separate issues. They're also not applicable to intangibles like software or consulting services. There are 11 Incoterms. It has changed over time. Incoterms 2010 had 13. There are now only 11 Incoterms. Write that down. There are 11 Incoterms. Incoterms are split into two groups, one that is applicable for any mode of transportation and one that is for sea and waterway. For any mode of transportation, there are 7 Incoterms for any mode of transportation. Those are Ex-Works, FCA, CPT, CIP, DAP, DPU, and DDP. There are 4 Incoterms specific to sea and inland waterway. Those are FAS, FOB, CFR, and CIF. The Incoterms for any mode or modes of transportation are EXW, Ex-Works, FCA, Free Carrier, CPT, Carriage Paid To, CIP, Carriage and Insurance Paid To, DAP, Delivered at Place, DPU, Delivered at Place, and DDP, Delivered Duty Paid. The Incoterms for sea and inland waterway are FAS, Free Alongside Ship, FOB, Free on Board, CFR, Cost and Freight, CIF, Cost, Insurance, and Freight. There are 4 groups in which the Incoterms are split. It's based on the first letters. So Group E, that's just Ex-Works. That's where the responsibility of the buyer is the greatest. Group F, which is FCA, FAS, and FOB. Then you have Group C, CFR, CIF, CPT, CIP, and Group D, which is DAP, DPU, and DDP. This is where the responsibility of the seller is the greatest. So Group D is the responsibility of the seller is the greatest. In Group E, there is no responsibility for the seller group, which means that everything is done by the buyer. Group F, inland freight, is included. In Group C and D, both inland and main freight are included. The difference between C and D is, in C terms, the shipper arranges and pays to the freight up to the destination, but the risks stop at the origin. Whereas with D terms, the shipper arranges and pays for the freight up to the destination, and he also assumes the risk to destination. So in C terms, the risk and the payment don't always align. So that's it for the introduction. The next video that you're going to see is going to get into the specifics about the Incoterms for any mode of transportation. So we are going to go into the names and all of the responsibilities and risks involved there.